Okay, so we now proceed to the cases with regards to real estate mortgage. So our first case is spouses Baisa versus spouses Plantila. And the facts of the case are the following. The case involves a real estate mortgage entered into by the petitioners involving their parcel of land in Cubao, Quezon City to secure the payment of their obligation amounting to 2.3 million pesos in favor of the respondent spouses. Upon the default of the petitioners, the respondent spouses commenced the extrajudicial foreclosure of the real estate mortgage to recover from the petitioner the total liability of 3.5 million pesos, inclusive of the principal and the unpaid interest. The petitioners, after a while, sued the respondent spouses in the Regional Trial Court in Quezon City to annul the extrajudicial foreclosure of the real estate mortgage and the public auction conducted pursuant to the extrajudicial foreclosure. They allege that all the proceedings relevant to the extrajudicial foreclosure were null and void, pointing out that there had been no power or authority to sell inserted in the real estate mortgage or attached thereto. So the issue now before the Supreme Court is whether or not the extrajudicial foreclosure was valid, despite the lack of provision in the mortgage deed granting special power to sell to the mortgagee. So the Supreme Court held in the negative and said that Section 1 of Act number 3135 provides that to enable the extrajudicial foreclosure of the real estate mortgage, the special power to sell should have been either inserted in the real estate mortgage itself or embodied in a separate instrument attached to the real estate mortgage. In the case at bar, it is not disputed that no special power to sell was either inserted in the real estate mortgage or attached to the real estate mortgage. Hence, the respondent spouses, as the foreclosing mortgagees, could not initiate the extrajudicial foreclosure, but must resort to judicial foreclosure pursuant to the procedures set forth in Rule 68 of the Rules of Court. The omission of the special power to sell the property subject of the mortgage was fatal to the validity and efficacy of the extrajudicial foreclosure and warranted the invalidation of the entire proceedings conducted by the sheriff. We now proceed to our next case. We have Dionisio Mojica versus Court of Appeals. The facts of the case are the following. On February 1 of 1971, Leonardo Mojica contracted a loan of 20,000 pesos from defendant Rural Bank of Kawit, and this loan was secured by a real estate mortgage executed on the same date. The contract states an agreement for the payment of the loan of 20,000 pesos and such other loans or other advances already obtained or still to be obtained by the mortgagors. So the loan of 20,000 pesos was fully and completely paid, actually. And a new loan in the amount of 18,000 pesos was obtained by plaintiff spouses from the defendant Rural Bank. With regards to the second loan, no formal deed of real estate mortgage was constituted over any property of the borrowers. The spouses Leonardo Mojica and Marina Rufido failed to pay their obligation after its maturity. So, respondent Rural Bank extrajudicially foreclosed the real estate mortgage on the justification that it was adopted as a mortgage for the new loan of 18,000 pesos. And the proceeds from the sale of the piece of land were applied to their outstanding obligation. So the issue now before the Supreme Court is whether or not the foreclosure sale by the sheriff by virtue of plaintiff's failure to pay the second loan had for its basis a valid and subsisting mortgage contract. So the Supreme Court ruled in the affirmative and says that it has long been settled by a long line of decisions that mortgages given to secure future advancements are valid and legal contracts, that the amounts named as consideration in said contract do not limit the amount for which the mortgage may stand as security if from the four corners of the instrument the intent to secure future and other indebtedness can be gathered. Furthermore, a mortgage given to secure advancement is a continuing security and is not discharged by repayment of the amount named in the mortgage until the full amount of the advancements are paid. Now let's proceed to our third case. We have LZK Holdings and Development Corporation versus Planters Development Bank. The facts of the case are the following. Petitioner LZK Holdings obtained a 40 million pesos loan from Planters Bank on December 16 of 1996 and secured the same with a real estate mortgage over its lot located in La Union. On September 21 of 1998, the lot was sold at a public auction after Planters Bank extrajudicially foreclosed the real estate mortgage thereon due to LZK Holdings' failure to pay its loan. Planters Bank emerged as the highest bidder during the auction sale, and its certificate of sale was registered on March 16 of 1999. On April 5 of 1999, petitioner LZK Holdings filed before the RTC of Makati a complaint for annulment of extrajudicial foreclosure, mortgage contract, promissory note, and damages. Petitioner LZK Holdings also prayed for the issuance of a temporary restraining order or writ of preliminary injunction to enjoin the consolidation of title over the lot by Planters Bank. Meanwhile, Planters Bank filed an ex parte motion for the issuance of a writ of possession with the RTC of San Fernando. Thereafter, the RTC of Makati granted petitioner LZK's petition and issued a temporary restraining order enjoining Planters Bank from consolidating its title over the property and also ordered the issuance of a writ of preliminary injunction for the same purpose. And as a result, the proceedings for Planters Bank ex parte motion for the issuance of a writ of possession was suspended by the RTC of San Fernando in view of the TRO and writ of preliminary injunction issued by the RTC of Makati. And on appeal, the Court of Appeals granted the appeal of Planters Bank and annulled the assailed order of the RTC of San Fernando. Hence, this petition for review by LZK Holdings. And the issue now before the Supreme Court is whether or not Planters Bank may apply for and is entitled to a writ of possession as the purchaser of the property in the foreclosed sale. The Supreme Court ruled in the affirmative, holding that under Section 7 of Act 3135, the writ of possession may be issued to the purchaser in a foreclosure sale, either within the 1 year redemption period upon the filing of a bond, or after the lapse of the redemption period without need of a bond. Furthermore, the Supreme Court has consistently held that the duty of the trial court to grant a writ of possession is ministerial. Such writ issues as a matter of course upon the filing of the proper motion and the approval of the corresponding bond. No discretion is left to the trial court, and any question regarding the regularity and validity of the sale, as well as the consequent cancellation of the writ, is to be determined in a subsequent proceeding. And such question cannot be raised to oppose the issuance of the writ, since the proceeding is ex parte. The recourse is available even before the expiration of the redemption period provided by law. And to emphasize the writ's ministerial character, the Supreme Court have in previous cases disallowed injunctions to prohibit its issuance, just as they have held that issuance of the same may not be stayed by a pending action for annulment of mortgage or the foreclosure itself. So those are the cases with regards to real estate mortgage. Thank you all for listening.